كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Dear brothers, dear sisters, alhamdulillah, we are on the 13th lesson. Alhamdulillah, and what this lesson entails is Kitabul Qadi ila al-Qadi, and within that there's going to be a term, Sijillat. So I'm going to explain that first to you, just like I'd like to do with everything. So again, in our Islamic jurisprudence, this term Kitabul Qadi ila al-Qadi refers to the letter of one judge to another judge. It's usually a formal written communication or letter sent by one judge to another judge. Typically when a case or legal matter involves multiple jurisdictions, right? Or when there's a need for judicial cooperation from another judge somewhere else because maybe there's somebody else there. So it could also be used for transfer of cases, when a legal case needs to be transferred from one jurisdiction or another. Because remember, in Islamic jurisprudence, a judge usually cannot make a judgment against an absent person, who might be in another jurisdiction. So they get the Qadi there to do it. So a Qadi might write to another Qadi, providing the necessary details and instructions to continue the case in that new jurisdiction. So that could be another reason. Yet another reason is request for testimony or evidence, which is part of the jurisdiction of another judge. So if witnesses or evidences are located in different jurisdictions, a Qadi might write to another Qadi requesting that testimony be taken or evidence be gathered on their behalf, rather than have to summon somebody all the way up to another jurisdiction. Rather have them give witness in front of another judge somewhere else. And then there's judicial cooperation. This letter would facilitate communication, collaboration between judges in different regions or courts, ensuring that justice is administered consistently and efficiently. And then you're going to come across a term called Sijillat, which is plural of records or registers. And again, in the context of Islamic law, that would be referred to the official records, right, or archives, you could say, that are maintained by the Qadi or the court. And they're crucial for obviously documenting proceedings, decisions and outcomes of cases handled by the court. So the purposes of this could be a judicial record keeping, obviously, right? Details of cases, who testified, evidence presented, final judgment, historical documentation, obviously, right? Reference for future cases, and transparency and accountability. So you get all of that from there. So that's Kitabul Qadi ila al-Qadi. That's the section we are on right now. And inshallah, that's what we'll be looking at. So, Kitab al-Qadi ila al-Qadi, Sahib al-Quduri, he says, وَيُقْبَلُ كِتَابُ الْقَاضِي إِلَى الْقَاضِي فِي الْحُقُوقِ الَّتِي لَا تَسْقُطُ بِالشُّبْهَةِ. So, right off the back, he says that a formal letter from one judge to another can only be accepted in those cases that don't get repelled and cancelled because of any doubt. So that would mean in hudud and qisas, you could not usually send a letter, right, regarding cases of hudud and qisas, because they're very sensitive cases and they require absolute proof, and it could just be an issue in the letter that would come about. So either shuhida bihi indahu. So this letter has to be accompanied by witnesses, right? So it's kind of interesting. This letter has to be accompanied by witnesses. So it has to be witnessed by the sender judge. It has to be witnessed there that he is the one sending it. أنه كتاب فلان القاضي وختمه. So the witness need the two people who are witnessing this, the two males, need to say that, okay, this is his letter and this is his seal, so it needs to be sealed as well. فإن كان الشهداء شهدوا عند القاضي الكتاب على خصم حاضر حكم بالشهادة على قواعد مذهبه وكتب بحكمه إلى القاضي الآخر لينفذه. So ويكون هذا في سورة الاستحقاق فإن المدعى عليه إذا حكم عليه وأراد الرجوع على بائعه وهو في بلدة أخرى وطلب من القاضي أن يكتب بحكمه إلى قاضي تلك البلدة يكتبه له ويسمى هذا الكتاب سجلا لتضمنه الحكم. So ultimately what he's saying is that this particular letter that he's going to, and I'll explain it soon, that this particular letter, the official formal letter that he writes and seals, that's going to be called the sijil, which was the singular of the sijillat. Right. So now I'll give you an example just so that you understand the text from the example. The example is a person purchased a book or anything from someone. After he purchased it, he probably went into a different area, and it turned out that it turned out to be somebody else's book that he'd purchased. It wasn't the ownership. It wasn't the ownership of the person he had purchased it from, meaning the seller. It'd been his brother's. Maybe it was an inheritance mistake. So the brother came and claimed it. So this third person, the brother of the person he had purchased it from, comes and claims the book, demands it, and it goes to court. But obviously this he puts the lawsuit in court, and the judgment is made in his favor. Okay, so now that means that the buyer, who was person B, has to give the book over to person C, who had rightful ownership of it, whereas B didn't have it. But person A, the buyer, has already paid person B. But this person C turns out to be the real owner, so he has to hand the book over. So now he's left out of pocket for the £10 that he had already paid for the book to the original seller. So the seller is probably in another area, and he's not under this judge's jurisdiction. So this seller who had to give, this buyer who had to give over the book to reclaim his money back, from the person who sold it to him, demands from the qadi, or seeks from the qadi, that he write regarding the judgment formally to the qadi of the jurisdiction in which the seller is. So then he can take it there and have that judge impose it on the original seller to give him his money back so he can reclaim his money. So hopefully that's clear what the story is. So he in Quduri it's very brief, but this is essentially what is understood. So he's saying that if the witnesses had given witness by a judge who's eventually going to be the one to write that specific formal letter, ala khasmin hadirin. Now obviously that particular judge had made a judgment for against the buyer based on the demand of the original owner that turned out to be the original owner, right? The buyer had the book in his hand, so he's the one who had been the defendant in the court in this jurisdiction, and the one who'd put the lawsuit through had been the original owner, right? The original seller's in another town, maybe that's his relative, as I said, it might be his brother. Anyway, حكم بالشهادة على قواعد مذهبه. So now that judge made the judgment based on the witnesses that had come about his original ownership. So the seller, the buyer had to hand it over to him. وكتب بحكمه للقاضي الآخر لينفذه. And now because he's asked him that, can you please help me get my money back from the person who sold it to me, because I didn't know. So he's the one who's writing the letter, formal letter, to the other jurisdiction in which the original seller lives. ويكون هذا في سورة الاستحقاق. So Imam Maydani explains that this text of Quduri refers to the case of where a third person comes out to be the real owner and demands it back, right? فإن المدعى عليه إذا حكم عليه, because the defendant in this case, who was the purchaser, when the judgment was made against him, وأراد الرجوع على بائعه, and now he wants to go and reclaim the money from the person who sold it to him wrongly, right? وهو في بلدة أخرى, but he's in another town. وطلب من القاضي يكتب بحكمه إلى قاضي تلك البلدة, and he has sought from this judge who judged against him to give the book back, he has asked him to write to the judge of that other area, يكتبه له. So he wrote the judgment for him. ويسمى هذا الكتاب سجلا, and he says that this formal correspondence is called a sijil. لتضمنه الحكم, because it includes and comprises of the judgment itself. Nowadays they might send an email or something of that nature, a formal, they must have some kind of formal, private, secure email system that organizations have, so they'll probably use something like that, right? Okay, so this is obviously the system of that time, which is still in practice today in many countries. As I said, when I visited the Imara Shar'iyya, which who run multiple, they have the Qadi al-Qudat there, the chief judge, chief justice there, but then they have multiple courts throughout the state of Bihar and Orissa and maybe in Bengal as well, and they have allocated judges in all of these places. So they, most likely, as far as I understand, they actually do everything by writing, right? Including writing letters to people and so on and so forth. So this will still apply to them. وَإِنْ كَانُوا شَهِدُوا بِغَيْرِ حَضْرَةِ خَصْمٍ لَمْ يَحْكُمْ بِتِلْكَ الشَّهَادَةِ. This provides a better understanding of what's going on here, and this brings in the idea, you know, the concept in Islamic law that you can't really make a judgment against somebody who's absent, right? Unless he's got a representative there. So he's saying that if they had given witness without the presence, in the absence rather, of the opponent, of the adversary, the defendant, لم يحكم بتلك الشهادة, then the judge could not give a judgment based on that witness and proof, because there's nobody present there to give the judgment against. لما مر من أن القضاء على الغائب لا يصح. It is invalid to give a judgment against an absent person. So this is now a more general case, that let's just say that somebody in a particular jurisdiction brought a case, a lawsuit, and he brings witnesses as well, but the defendant is not present, he is in a different locality. So the judge can listen to everything, write that down as a report, and then send it over to the other jurisdiction to have the defendant present there, and then the judge there will provide the judgment there. وَلَكِنْ كَتَبَ بِالشَّهَادَةِ. So because the witnesses are here, and he's taken their proof and he's listened to that, so he records that لِيَحْكُمَ بِهَا الْمَكْتُوبُ إِلَيْهِ عَلَى قَوَاعِدِ مَذْهَبِهِ, and he then sends that to the judge in the other area to use in his judgment. وَيُسَمَّى هَذَا الْكِتَابُ الْحُكْمِ. So in Arabic this is called a legal written document, a legal communication, you could say, right? A legal communication. لأن المقصود به حكم المكتوب إليه, because the whole purpose of it is to pass a judgment against the defendant there in the other one. وهو في الحقيقة نقل الشهادة. In another sense, it's in reality what you're doing is you're transferring the proof from here to there, because the witnesses can't be there even though the defendant is there, and the judgment can't be made here because the defendant is not here. So it's a way to do half the job here, half the job there. Interestingly, what he then says is وَلَا يَقْبَلُ الْقَاضِي الْمَكْتُوبُ إِلَيْهِ الْكِتَابَ إِلَّا بِشَهَادَةِ رَجُلَيْنِ أَوْ رَجُلٍ وَامْرَأَتَيْنِ. Okay, as I said, nowadays there's probably the secure ways of transferring this kind of communication, but in those days this letter could not be accepted, right? This communication would not be accepted by the judge in the other area except with proof of two men, or the witness of two men, or one man and two women, that this is the letter of that judge. So these are not the witnesses to the case and the lawsuit. These are additional witnesses to prove that this letter is from that judge. لِاحْتِمَالِ التَّزْوِيرِ, because of the possibility of tampering that might have taken place on the way, because there's people that are going to be, you know, transporting this letter over, or this sealed communication over. وهذا they don't have to do this all the time. وهذا عند إنكار الخصم أنه كتاب القاضي. This will only have to be done, he says, if the defendant there, who is in the other area, creates doubt and says, no, I don't believe that this is the true letter. As I said, nowadays they probably don't need to do this, at least not in developed places. They probably still have this system, in where they use everything, they do everything by letter and formally and by post, by mail. وَأَمَّا إِذَا أَقَرَّ. However, if the defendant is fine with it, yeah, I agree with it, it's okay, فَلَا حَاجَةَ إِلَىٰ إِقَامَةِ بَيِّنَةٍ, then you don't need these individuals to witness that it is their letter. But remember, these witnesses were separate to the witnesses of the case. This is just witnesses to say this is his letter. That means that there must be two people who probably come after having witnessed the judge writing it, sealing it, and then they come over and transport it here as well. Subhanallah. وَيَجِبُ عَلَى الْقَاضِي الْكَاتِبِ. Now, the way this, again, it's a bit, it could have been done in a bit more order. He's saying that the judge, the sending judge, the one who sent the communication, it's necessary on him أن يقرأ الكتاب عليهم. In the case where proof is needed, right, where evidence is needed, he has to first read out what's written in that letter to these witnesses, these additional witnesses, ليعرفوا ما فيه, so that they recognize and know what's written inside, right? They're not just seeing an empty, a sealed letter going from one place. Yes, that's the one, because anything could have happened in between, right? Because the carrier may be somebody else, the transporter may be somebody else. So they have to first recognize and know what's inside it, so the judge reads it out to them. Or يُعْلِمُهُمْ بِهِ, or he informs them what's written inside. He doesn't have to read it word to word, but he tells them, this is, broadly speaking, this is what it says. لِأَنَّهُ لَا شَهَادَةَ بِدُونِ الْعِلْمِ, because how can they bear witness that this is from him without knowing what's in there? ثُمَّ يَخْتِمُهُ بِحَضْرَتِهِمْ, then he would officially seal it, the way they would seal things with the wax, in their presence. وَيُسَلِّمُهُ إِلَيْهِمْ, and then he would hand it over to them. نَفْيًا لِلشَّكِّ وَالتَّرَدُّدِ مِنْ كُلِّ وَجْهٍ, so they would actually they would be the witness, they would also carry it, they would transport it as well in this case, right? This is to negate any kind of doubt or uncertainty, as far as possible from every side, to the best of their ability. Again, nowadays with secure email, it's probably much easier, even though that's maybe not 100%, because people can hack things and so on. قال في الهداية وشر الزاهد أما الختم بحضرتهم. So Hidayah in the Sharh al-Zahidi, they've clarified that the seal in front of them in their presence, and likewise for them to remember what's in the book, then this is a condition, for them to be proper witnesses to it later if it's demanded. That is a condition according to Imam Abu Hanifa and Imam Muhammad. Imam Abu Yusuf's final view on this matter was that none of this is a condition. All they need to do, all the judge needs to do is say, look, this is my letter, you need to pass this on, right? Letter and seal, that's it. As long as the seal is not broken, it must be from the other judge. He doesn't have to tell them what's inside it, and doesn't have to seal it in front of them. He just has to hand it over sealed, right? Because it's related from him that the seal is not necessary, it's not a condition. And probably the reason why he's saying this is because he was saying it practically rather than theoretically. Rather than, he was looking at this case less as a hypothesis, right, and more as a reality, because it says that when he became the judge in Baghdad, he became the judge of the chief jurist, the chief justice rather, in the Abbasid, under the Abbasids, and he realized that all of these things are not easy to do if you put too many stringent measures in. So that's why he lightened the burden, and that's why the Imam Maidani says, وَلَيْسَ الْخَبْرُ كَالْمُعَايَنَةِ. Seeing something is, or rather just hearing something is not like seeing it itself and experiencing itself. And he says that this is also Shamsul A'imma as-Sarakhsi's preferred opinion as well. Now, Qasim ibn Qutlubugha, in his Tashih al-Quduri, which is that work on Quduri that preponderates opinions when there's a difference of opinion between Sahibain or Imam Abu Hanifa, Imam Abu Yusuf and Imam Muhammad. He says that our Shaykh, and he refers to Ibn al-Humam with this Kamal Ibn al-Humam with regard to the author of Fathul Qadir. So he says in Sharh al-Hidayah, وَلَا شَكَّ إِنْدِي فِي صِحَّتِهِ, I have no doubt lingering with regards to its validity, because فإن الغرض إذا كان عدالة الشهود وهم حملة الكتاب فلا يضره كون غير مختوم مع شهادتهم أنه كتابه. Ultimately, if you're using witnesses that are trustworthy anyway and reliable to transport the letter and say that this is from him and two of them as well, then you don't need these additional measures, because you're already trusting these guys that they would not have tampered with it on the way. Okay, so you don't really need all the additional measures. This measure is sufficient that you're handing it over. You don't even have to seal it with an official seal. You just have to hand it over to them, and you have to trust them that they would have conveyed it exactly as it was. نعم إذا كان الكتاب مع المدعي ينبغي أن يشترط الختم. Yes, if it's the claimant now, because remember, the defendant who had to give up the book, now he becomes a claimant for his money back from his seller, right? So he becomes a claimant now. If he's the one who takes the letter, the official correspondence, and he's bringing it over, now that could have some tampering because he's an interested party. Okay, so that's why he's saying if that letter was with the claimant himself, ينبغي أن يشترط الختم. So in that case, a seal is at least necessary, or it's appropriate to make that as a condition لاحتمال التغيير, because of the possibility that there could be some alteration made. إلا أن يشهدوا بما فيه حفظا, unless those witnesses that are coming along also know what's going on, and they're able to witness by remembering by memory what was, what was the original written piece there before, what it was supposed to include. فالوجه إن كان الكتاب مع الشهود. So he's saying that the conclusion is that if the letter is in the possession, while transporting it, in the possession of the witnesses, أن لا تشترط معرفتهم بما فيه, there's no need for them to know what's inside it, ولا الختم, and there's no need for any official seal either. ولتكفي شهادتهم أنه كتابه مع عدالتهم. As long as they're upright, that's enough for them to say that this is the actual letter that judge has sent with us for this case here. وإن كان مع المدعي, however, if it was brought along and transported with the mudda'i instead, which means the claimant, اشتراط حفظهم لما فيه فقط, then at least the witness, you still need witnesses there if the other guy demands, then those witnesses need to know at least what's in there, just so that it's clear, right? It's clear. So that would be the conclusion here. Right. فإذا وصل إلى القاضي. Now when this particular correspondence letter reaches the judge in the other area, لم يقبله إلا بحضرة الخصم. He can't accept it and judge by it without the presence of the defendant, right? لأنه بمنزلة أداء الشهادة, because remember what this letter includes is the witnessing of the witnesses, right, who are going to witness against this defendant that yes, it was not his property but the other person's property. That's why he now owes money back to the person he'd sold it to, right? So witnesses have to be the witness has to be presented in front of the defendant. So the defendant better be there. The judge can't just listen to himself then call the other guy in, because he has to be there to listen to what is being brought as proof in front of him or for him. فإذا سلمه الشهود إليه أي القاضي بحضرة الخصم. When these transporting witnesses have presented and handed over this communication, this letter, to the judge in the presence of the defendant now, نظر القاضي إلى ختمه أولا. This is now the procedure. Again, it's very formal procedures. He will have to check all of this out if it's correct. So he says, number one, he will look at the seal ليتعرفه, to see if he recognizes it. and he can identify that it's not somebody else's seal. فإن شهدوا أنه كتاب فلان القاضي سلمه إلينا في مجلس حكمه وقرأه علينا وختمه بختمه فضه القاضي. So he has to now officially let them witness, let them testify that this is the letter of such and such a judge who handed this over to us during his judgment session. He read it out to us, he told us what's in it, then he sealed it with his seal in front of us. Only then can the judge now فضه القاضي, only then can he open the letter, break the seal, وقرأه, then he will read it, ونشره على الخصم, he will then communicate that, he will let the defendant know what's inside it, وألزمه ما فيه, and it's just a very simple case now that he will now implement this judgment on him. Because remember, the judge, the witnessing is what's included in there, the two witnesses or the 1 + 2 witnesses, whatever it was on the other side, that's all packaged for him, ready just to implement and pass the judgment against this person. Imam in the Sahib al-Hidayah says this is the way it's going to be according to Imam Abu Hanifa and Imam Muhammad. It seems like they're together in this case, who we call the Tarafain. Imam Abu Yusuf says إذا شهدوا أنه كتابه وخاتمه قبله. He says that you don't have to do this long procedure as long as they bear witness that this is that Qadi's judgment, it's his letter and this is his seal, he can accept it, and then the rest is the same. And ولم يشترط في الكتاب ظهور العدالة للفتح والصحيح أنه يفض الكتاب بعد ثبوت العدالة. So he hasn't made any additional conditions there that in order to open it, then they must they must be upright and so on and so forth. The Sahih opinion is that he can open the book, open the letter after it's established that they are upright, as Khassaf has mentioned, because sometimes if it's not clear, then they might need more witnesses, he says. Right. وإنما يقبله المكتوب إليه إذا كان الكاتب على القضاء حتى لو عزل أو مات أو لم يبق أهلا للقضاء قبل وصول الكتاب لا يقبله لأنه التحق بواحد من الرعاية. There's another caveat here, but I guess it's not going to happen too often. If the sender judge wrote it, signed it, sealed it, etc., sent it over, but before the second judge could do anything with it and pass the judgment, this first judge has either been dismissed or has died or is not doing the job anymore as such. This letter holds no weight anymore, right? So what we've understood from these particular rulings is that a judgment of a judge, regardless of how much procedure he's done, it's only valuable and in effect as long as he passes a judgment on it. If he's done all of the work before, but he hasn't passed the judgment and then he's dismissed, then all of that goes to waste. Somebody has to restart the whole process from scratch. That's the way it seems, right? That's the conclusion I'm reaching after seeing a number of these issues, right? That for a judgment to be valid, it has to be done fully from the beginning to the end. If half the procedure or most of the procedure but the judgment was not given, and then that judge died or dismissed or lost his capacity or whatever it is, then you have to start again. That's what he's saying here, because he then just becomes like any normal person. So why should we take that? Then it needs to be done again under the new judge. وَكَذَا لَوْ مَاتَ الْمَكْتُوبُ إِلَيْهِ. Now this is a bit pedantic, that if the sending judge is still around and he's written it specifically to Judge Qasim, right, whose name is Qasim, and Judge Qasim dies or is taken off before the letter reaches him or before he's able to make a judgment, then again this becomes useless. They'll need a new letter to come to the new judge, unless he says إِلَّا إِذَا كَتَبَ. That's why it was probably better for the first judge to leave it more general. إِلَّا إِذَا كَتَبَ إِلَى فُلَانِ ibn فُلَانِ قَاضِي بَلْدَةِ كَذَا. Yes, if you'd written that this letter is to Qasim ibn Yaqub, the judge of Nahawand, right, or the judge of London or Nuneaton or New York, right? If he's written that, and he's also, that's why they should probably write this, وَإِلَى كُلِّ مَنْ يَصِلْ إِلَيْهِ مِنْ قُضَاةِ الْمُسْلِمِينَ, and to every other judge of the Muslims that this could reach, then it's okay. So he's sufficiently broadened it. So yeah, he's written the person's name, that's the preference, but otherwise any judge of New York or any judge at all, this would be sufficient because he's allowed the scope. So they're very particular about the scope of these things. So in some of these cases, he can have a general scope. And in some of these cases, he doesn't want a general scope, right? Essentially, that's how you understand this, okay? بخلاف ما إذا كتب ابتداءً. Now, the other way to do it is إلى كل من يصل إليه, to anybody that this letter reaches, anybody that is in this position, essentially, right? To whoever this relates to, then it's okay. Our Mashayikh said that's fine, because in that case then it is not specifically addressed to an individual, then it's okay. So in the first case where he wrote to such and such Yaqub ibn Sulaiman, for example, the judge of New York, and to anybody else, right? Then that means he primarily intends Yaqub or Qasim ibn Sulaiman, Yaqub ibn Sulaiman, as I mentioned, and the others are subordinate. So he's thinking ahead that just in case he's not there, then at least somebody else would be subordinate. But it's just best to write general. But sometimes you might need to write it specifically because he wants a specific judge to take care of it, right? So there could be reasons. وَلَوْ كَانَ مَاتَ الْخَصْمِ. Okay, what happens if the letter reaches, both judges are fine, they're still there, but the defendant is gone, he's died, right? يَنْفُذُ الْكِتَابَ عَلَى وَارِثِهِ. Then obviously the defense will be his inheritance, because they're going to inherit his wealth, and that part of the wealth doesn't belong to them. That part belongs to this person whose right it is. So that second judge will pass this judgment over his inheritors, so that, because now they stand in his place and they have his wealth, so they will have to pay. Right. ولا يقبل كتاب القاضي في الحدود والقصاص. I think we clarified this before, but he's making it very clear now that it is a letter, an official letter from one judge to another is not acceptable in hudud and qisas. Hudud are those strict, stringent punishment penalties as such, and in retaliatory cases of life or limb. لأن فيه شبهة البدلية عن الشهادة, because clearly it is not the exact same as live witnesses coming and witnessing. It is all put into a letter. Now, there could be some tampering. There's a possibility, even though we've done our best to ensure that it's not like that, right? Even if it's sent by secure mail nowadays, there's a possibility, right? So because there's that slight doubt that this is a kind of a subordinate thing that stands in place of the original, that's why فَصَارَ كَالشَّهَادَةِ عَلَى الشَّهَادَةِ. So this is exactly like, you know, the case we had in the previous chapter where the original witnesses couldn't turn up, so they made somebody else a witness to their, to their witnessing. So it becomes like that. وَلِأَنَّ مَبْنَاهُمَا عَلَى الْإِسْقَاطِ. Very interesting statement, that hudud and qisas, there's always an effort in there to try to drop the penalty because they're so severe. It's cutting somebody's hand, flogging somebody, stoning somebody to death. So they're always trying to find a way out of it because it's so severe. But it has to be done when it's definitive and when there's no way out of it, right? But that's the purpose. So this is not good enough. This is just not good enough. وفي قبوله سعي في إثباتها. And if you're going to accept even this kind of evidence in this, right, for small money matters, even big money matters is fine, but not for when it comes to physical punishment, right? Or taking a life or a limb. In that case, then, you know, you wanna be very, very cautious in that regard. Okay, now to complete the discussion for today's session, the next section is regarding istikhlaf al-qadi na'iban anhu. Is a judge allowed to deputize somebody else if he can't be present that day, if he needs to go off somewhere, he's sick or whatever? Can he deputize somebody else? Now, of course, in larger areas, they'll have multiple judges and everybody, you know, will have their turns and there'll be people standing in place of another, but they're all officially judges, so that's fine. But this is a case where the formal judge who's been appointed, is he allowed to appoint somebody else in his place? Does he have the right to appoint somebody else in his place? So the thing is that he's not allowed to do that. They say وَلَيْسَ لِلْقَاضِي أَن يَسْتَخْلِفَ عَلَى الْقَضَاءِ لِأَنَّهُ قُلِّدَ الْقَضَاء, because he's only been appointed as a judge, دون التقليد, not as an appointer of a judge, right? So this is just the same thing like if somebody's made an agent, they can't make somebody else the the agent, a sub-agent, unless they've been permitted to make the other person an agent. Right, so that's quite clear. However, let's just say that he does, for whatever reason, he didn't want to speak that day and he had somebody else sit there and legislate for him, adjudicate for him, and the second person in his deputy in his presence, in the proper judge's presence, gives a judgment, or the second or this guy gives a judgment and he approves it, meaning the original judge approves it, then it would be fine, because ultimately he is approving it and he's fine with it. So clearly it's seen as him doing it because he has a say in it. It wasn't done unilaterally by the other individual. إلا أن يفوض ذلك عليه, unless he's also been consigned the right to appoint judges, right? Clearly saying. So either it's clarity that, okay, you are a judge and you can also appoint other judges, right, if you need to. Like say, وَلِّ مَا شِئْتَ, you can appoint whoever you like. Or it could be by indication, implicit, that he is made Qadi al-Qudat, the Chief Justice. Now the Chief Justice is obviously in charge of all of the other judges. So he has the right to fire and dismiss. He has the right to hire and fire, right? He can take somebody on, appoint somebody, and he can dismiss them. Because, in fact, in this case of being made the Chief Justice, that is a stronger, that at least in Islamic terms, that is even stronger than telling him clearly that, hey, you can appoint another judge. I mean, you're the Chief Judge, you can do what you want, essentially, right? So in that case, he should be able to definitely put somebody else in his place, but can he fire somebody? There's a difference of opinion there, that he doesn't have to be allowed to fire in that case. In the case of when he's told you are allowed to appoint somebody else, the first case where it's clear you can appoint somebody else, that doesn't mean he can fire. But in the case of the Chief Justice, he can hire and fire, right? So he has both, because al-Qadi al-Qudat هو الذي يتصرف فيه مطلقا. The Qadi al-Qudat has to be the one who can do whatever he wishes and has absolute, scope and right to hire or fire, right? So that's the end of our 13th lesson. Hopefully that makes it very clear the judge's role in this regard, and Kitab Adab al-Qadi ila al-Qadi, right? Or Kitab al-Qadi ila al-Qadi. And inshallah we'll see you in the next lesson. Assalamu alaikum wa rahmatullahi wa barakatuh.